Yeah, it does help to start the videos after you start. So in other words, I started the video, but I didn't put myself in the room. So that was well done. Fantastic. Um, Not legal advice. Please like, subscribe, share, comment, do anything like that. Thank you for watching. Happy whatever time it is to you. Obviously, this is not intended as legal or financial advice. And obviously, if you listen to it carefully, you can conclude that on your own. But hopefully, it will address some points that maybe you were thinking about or help you think about things in a different way. So, tonight we're going to talk a little bit about MMTLP, MMAT, finger motion, GTII, and some other stuff. And we will see how it goes. Before we start, of course, I tried to draw a circle before we started, but it was pointless. Additionally, gee, a boiled egg in the morning is hard to beat. And finally, I make apocalyptic, isn't that how you say it? Apocalyptic puns like there's no tomorrow. Anyway, so those were three fine jokes, obviously. Um, Show those to your dog because dogs like my humor in particular. So, anyway, quickly about finger motion. So, what I wanted to address obviously, it's an interesting stock. I'm in it, not financial advice. It's interesting the movement. Doesn't look like there's a lot of shares to trade. The interest rate, the borrower rate, which is the share lending rate, which I did a video on, is very high. I think it's like 130 or 140%. So there's not a lot of shares available. So the stock movement is interesting to see who's moving the stock. But on top of that, there's been a few short reports, and one that I responded to, and another one I'm responding to now. And this one goes to TD, etc. And it's pretty interesting because they have responded to a couple of letters. This is regards to the capybara short report, and TD and Benzinga publishing that. I represent, as I'm sure you all know, busy as to this particular matter at this time. So I've had a few communications with TD. In essence, they say, we're not responsible. We don't vouch for the accuracy or the reliability, and you shouldn't make decisions based on that. I don't think that's how they disclose it, by the way, when it's posted. Maybe it's presented in a slightly different fashion, but in essence, that's what they are saying, and which I found to be, very, very surprising. Of course, that's my summary of what they said, but I can read you a part of what they said. So let's see, just for accuracy's sake. They say that TD uses third party research and tools obtained from companies not affiliated with TD Ameritrade and are provided for informational purposes only. TD Ameritrade does not guarantee its accuracy, completeness, or suitability for any purpose and makes no warranties in respect to the results to be obtained from its uses. Now, there's some other nonsense that's referred to in there, but it doesn't talk about defamation or other tortious acts, and they don't explain the fact that it's. And I've sent that to them in this letter, so they receive something that talks about their CEO accuses him or her of committing crimes, and they don't review those documents. Are you saying they just print everything in a reckless manner without any regard to the content? Is that what they're saying? Because if that's what they're saying, I don't really think that's a viable position. So I have that last letter. It's the second response we received. I'm going to reply to that letter. And that reply is going to be something to the effect is got your letter. Seems like you're saying you don't review anything and you don't vouch for the accuracy of anything, and buyer beware, and you don't care about defamation, etc. And by the way, besides defamation, which is false statement about somebody, There's also other claims that might fit this particular situation. There's claims, at least in California example, for interfering with someone's business relations. That might also apply also, and that can be done negligently or intentionally, etc. So there's a bunch of claims. So anyway, I'm going to send out a communication to them, to TD Ameritrade, and ask them to show me reason and authority for the grounds for me not suing them. So I want them to show me, justify their position, to show me why we shouldn't sue them for their reckless conduct. And I'll be interested to see what their response is, or if they respond. And based upon the response, then we will take the next action. So that is related to finger motion because of the false reports and false commentary. And that includes also false information regarding earnings reports and vague, anonymous analysts. It's really seedy, and you wonder motivation. But anyway, based upon the response from TD, we will get some more information. And of course, I'm following finger motion and will continue to follow false reports and deal with them. So that's one. Two, MMTLP, I appreciate all that's going on. I know a letter went out by a senator from Idaho. I won't use his name because I often mispronounce his name. It starts with a C and ends with an O. I appreciate the letter. A nice progress. I don't know if who was involved in the preparation, but to all who were involved, thank you for your work product. Uh, uh, Perhaps you considered this and you elected not to, or perhaps the senator didn't want to include it, but a drop dead date, or in other words, do it by this date, or we'll have to consider different options, I think would have been a stronger way of proceeding. But, I'm Monday morning quarterbacking. On top of that, and I've been a proponent of this for quite some time, and perhaps everybody is, but I think a subpoena is going to end up being necessary because I don't know, of course, what's going to happen. Of course, not legal advice, not financial advice. I really have no idea. But in my dealings with parties where they were reluctant to turn over documents, etc., it usually took more than just a please to get them to comply. So this might be a different occasion, but I'm still expecting that a subpoena may be necessary. I know how reluctant Congress is to issue subpoenas, but I think they have to be prepared to do that if there is no proper response. So I hope that the senator's letter does not fall on deaf ears. In other words, that there's a response that's not responsive and then it doesn't get followed up with a subpoena. But anyway, not trying to be picky here, but that was my view. So I appreciated the letter. I think it was progress. I have my doubts about whether additional actions will be necessary, and I would prefer if those occurred now as opposed to later. That's just my feeling. So we will see. But again, I support everybody who was involved in that. And um, if they want to talk about subpoena, I'm happy to talk about that also. So that's MMTLP. On my side, it's funny. On my side, I'm involved in the arbitration. We were waiting for a third arbiter. So my arbitration with Fidelity before a FINRA panel requires 3 arbiters based upon the amount in controversy. In other words, the amount that's at issue. I had one arbiter excluded for cause, so he was kicked off. So we had 2. A new one was just appointed. I didn't have a choice or direct choice in that. I have an objection to the proceeding based upon the way the arbitration panel was selected. I filed another objection today as to that. I'm asserting that there's a rule that requires them to have a panel that does not have a conflict. I think they provided me a panel that was full of people with conflicts based upon a particular disclosure document. And I had to get rid of one arbiter because of a conflict. So obviously that would apply to that arbiter too, who they had chosen to appear. So I have an objection to that. I also put in a formal notice that the Senate and House are conducting a formal investigation of MMTLP. I included a copy of the letter from the senator, or at least something like it. And I asked the arbiters to go in the public domain, and I described what the nature of the action was. And I said, go out there and check on it yourself. Check to see that Congress is investigating the same thing that you're going to be adjudicating, and you might want to see what the congressional members are asserting about this situation before you take a look at it. So, and I also attached a copy of the letter, but I'm hoping they do their own independent research, and I've obviously now put it into their mind about the grander scope of the issue, and I think that will have a positive effect. So I, I I asserted that objection. That's one, and then on top, and I included a copy of the letter. I also served another set of discovery. I served a set of interrogatories, an interrogatory. So I have I think 4 special motions that are pending for special discovery based upon the extraordinary circumstances of MMTLP, based upon the U3 halt, and those are pending. On top of that, although in response, the other side said, why don't you just do it in terms of interrogatories and other discovery first, even though I know they won't respond. But just to call their bluff, I did. So I did that today. I sent out a small set of interrogatories asking questions about more names of people that were involved, communications they had, who they had with SEC, FINRA, questions about the U3 halt, etc. That was in part, but on top of that, I asked for documents. So I asked for a whole litany of documents that involved communications between Fidelity and FINRA, the SEC, any third parties, about the U3 halt, about the share account, about any communication with shareholders post December 9th, and a whole bunch of categories. I think in all, I had 25 different categories of documents up through December 9th and after December 9th, trying to basically address any communications that Fidelity could have possibly have with regard to MMTLP and the timing. And so that was served on the other side today, too, along with the interrogatories. So 25 different categories of documents I have requested, in addition to the 4 special motions and the interrogatories. Obviously, I expect to get pushback on this from the defendants, who claim there's nothing to see here. There's nothing wrong, as all we know. There's nothing wrong here, and that's why the Senate and the House are investigating it. But that's their position. So, do I expect them to be open and fair with discovery? No, and I hope they hear this, because that's not been their take to this point in time. And I'm sure we're going to battle, but so be it. As I've said multiple times, I'm here for the duration, and I'm trying to get information that will be helpful to the MMTLP cause, and perhaps to other causes too. Not why I got involved originally, but indirectly it might help on other matters. So 2 items of discovery were served on Fidelity, plus another objection to the arbitration panel. That was today, and we will be selecting a date for the next initial hearing. We had one, but it was canceled because of one of the arbiters being kicked off, and that will probably occur sometime in November. Then we'll probably have some schedule set up for discovery, for additional discovery, hopefully. And then we'll have a hearing date set out for trial. And obviously, I'll keep you apprised, as I'm doing right now, of all that. So that's MMTLP. So we heard about the letter to the senator and that being productive, heard about my update about my Fidelity arbitration. And again, anybody else who's in arbitration or is considering arbitration, more than happy to discuss that with them. Last but almost last but not least, MMAT. I did a video about that, and I again, Not financial advice, not legal advice. I would like an explanation as to the reason for the departure of George Palacaris. It really makes me uncomfortable. Of course, I'm not telling anyone what to do or not what to do, and I have no concerns. I looked at the background of the successor. He seemed very, very well qualified, even though don't know him. But he seems very well qualified in industry and experienced. But the fact of the abrupt departure of Palacaris really concerns me. And in fact, it concerned me enough that, and again, not financial advice, it would concern me enough that I got out of it. I just didn't like the way it felt. Now, that's notwithstanding the fact that after careful review, and thanks, Mark, um, they complied technically with the rule to the extent that that was a material event they had to disclose. So they had 4 business days to disclose that. They technically did it within 4 business days, even though it took 6 or 7 days to disclose, but part of that was a weekend. So they did it, but they certainly didn't do it as fast as they could. It sounded like it was rushed. I didn't like the fact that Palacaris was removed. So in my mind, if a client, and again, not advice, but if somebody came into my office and they just gave me those facts, and I would say that without a disclosure from the company as to the reason why Palacaris left, I would give a recommendation to my client not to get involved. Because I would say, what happens if that disclosure or the departure of Palacaris is material to the price of the stock or the business? Um, I couldn't tell you to go into a company like that without that disclosure. So if it were me, I'm not in it anymore. But if it were me, I'd ask the company to tell me why Palacaris uh, got out, and perhaps they'd tell you we can't tell you. Okay, so be it. At least you know they can't tell you. But perhaps they'll tell you the reason, and probably maybe it's an innocuous reason. Maybe it won't affect your decision making at all. But I think as a shareholder, you're entitled to know the reason why the head of the company was removed out of the blue, because that really concerned me and it concerned transparency and whatever. Now, I did hear some people say some concern about Palacaris representing himself as a CEO after his departure, because in the release, it looked like his departure was the 10th. A new CEO was appointed on the 16th, I believe the 16th. And I looked on YouTube and it appeared there was a conference that maybe he attended, but it looks like the conference was uploaded to YouTube after the 10th, but it looks like the conference, and I think it was a Canadian conference, occurred before the 10th. So I don't know if that's what the reference is to. And I know it was confusing. I kind of spent some time looking at it. Um, and perhaps he didn't know on the date of that Canadian conference that he was going to be terminated or removed on the 10th, perhaps. And perhaps there's some other event that everybody's talking about, but that's what I saw. A Canadian conference that I think happened on the 5th, but it being posted on YouTube and referencing a date like on the 12th. So if anybody has a different date, please comment, obviously. But again, it concerns me without a disclosure about why he left. I want to know, because if I'm a shareholder, if it's about products or something like that, I think it's something I need to know. So that disturbed me, and that if I was a shareholder, that's something I would ask for myself. Last but not least, I found this amazing article regarding Palantir software that I hope I could find now, and I can. Here it is. Amazing. It's really incredible. So, we've heard about the SEC, and the article is entitled, this would caught my attention. I'm familiar, and I think I talked about it slightly in a video. Palantir Technology is some kind of data collection company, so it's able to ascertain where all your data is, go get it, and then categorize it so it's useful to you in whatever task you're using. It's used in defense for the countries such as the United States, obviously. I think it was used by and provided to Ukraine for their defense, and has been characterized as being very successful. So they do that, but they also do a lot of other platforms, and they do a financial platform. So I found this headline that I thought was amazing and really gave me a lot of interesting feelings. So I'm just going to read a little bit of it and the headline. Headline is SEC's newest enforcement weapon, powerful software. And they reference, I'm just going to skip around, it detects insider trading and other illegal activity. And this was done by the SEC engaging Palantir Technologies, a software company that's used to foil terrorists. Um, and they talk about Palantir Technology as one of the big, involved in a lot of big data projects. And the way the software was originally developed was one of the founding members of Palantir was also a founding member of PayPal. And to protect uh, PayPal and detect fraudulent transactions with PayPal, they developed this financial software uh, that was, I guess, designed after or inspired by apparently the Lord of the Rings. Um, I can't explain it, but that's apparently what it was. So, what it does is it provides a platform for the SEC to find evidence of illegal activity much more quickly. It links trading records to personal contact information from paid databases with tips, complaints, and referrals, and everything else. And I thought that was fascinating. And in fact, on top of that, the power, and this is what the SEC is declaring, the power of the Palantir software for the SEC was um, it looked for incidents of insider trading, pump and dump schemes in penny stocks, accounting fraud, and violations of U.S. Foreign Corrupt Practices Acts, among other activities. And they just extol the virtues of this software that will let them catch all this manipulative and deceptive practices. And then I looked, of course, at the date of the article, and it's from February of 2014. So it's almost 10 years ago. The SEC and Palantir Technologies is around and is considered to be an expert in this area. And I know that the SEC uses Palantir for detecting insider trading, and obviously they could use it for detecting all kinds of manipulative practices. And in fact, the type of practices that are undertaken with regard to naked shorting would appear to be absolutely perfectly suited for Palantir Technologies software that the SEC is using right now, in that it can look at vast amounts of data and properly characterize it into useful groups. So you can use it to detect suspicious activity, to flag transactions, to locate bad actors. So why hasn't the SEC done that? They have it. They've spent millions of dollars. In 2014, that article said it was a multi-year contract. They spent millions of dollars. They brag about their software. So if they brag about their software, they have all the information that we are requesting, whatever share count, whatever defects in transactional records, whatever improper trading, they have it because they got it from Palantir. This is a over and above the blue sheets. They internally have the means and records. So don't let them fool you, and demand that they disclose what Palantir has given them the opportunity to disclose. And I urge you all to reach out to Palantir. I think it's based in Colorado, it was originally in the Silicon Valley. Reach out to them. Explain the perils that we are in. Explain that their software can be a aid to curing a problem that impacts literally millions of Americans. So anyway, usually a lot of fun here, and it's still fun. All these great jokes, but that's the last thing I have to say about the SEC. I obviously have a lot of problems with that SEC. They have this information, not disclosing it. Anyway, everybody keep the fight up. Be well. Hope this was helpful. Take care. Have a great night.